certainly believe that it wasn't.
I don't understand how that means you didn't have time that afternoon, or Sunday, or Monday, or Tuesday, or Wednesday, or Thursday, or Friday, or Saturday, or Sunday, or this morning. That's the first day from the district court. You've had time, correct?
Your Honor,
We've had time, yes or no?
We've had time. It's clear that we went to this court. Your Honor, certainly too, this is not, I believe, an issue, the FRAP 8 compliance that plaintiffs have raised. So it's by itself may have been forfeited because that is not an argument that I believe that plaintiffs have raised. But before that, we had already sought a first stay.
You admitted it right in your filings with us. You teed it up. They didn't have to raise it. You teed it up in your filings that we didn't do this. Do you know how often the government has asked this court to dismiss stay applications because someone didn't first ask it before?
Your Honor, I acknowledge that is a common course in cases. There is nothing remotely ordinary about this case. It's certainly not.
What is very ordinary is that you had plenty of time to ask first stay. And
I don't.
You really didn't, but you did have. You had the time to type into your briefs here. We didn't ask the district court for a stay.
Your Honor, because we thought, frankly, candidly, we hoped this court might act more quickly, and we therefore wanted to get relief as soon as possible, given the stakes of the issues presented.
I guess we would have thought with the stakes that you would want to cross your procedural T's and dot the I's.
Your Honor, given the extraordinary importance of this case and the fact that it's presented.
Case exception to, I mean, it seems to me all the more reason to ask the district court for a stay if it's important. I mean, is the government now of the view that we should adopt as a ruling in this court that when it's extraordinarily important, but there's still plenty of time, you don't have to ask a stay from the district court first or from an agency first?
Your Honor, we disagree that there was plenty of time, and we went to this court.
More than a week?
Your Honor,
Your
Honor, to the extent that this court believes that exhaustion is important, we're happy to do so before the district court. We expect that we would get an almost instantaneous denial. If that's something that is holding up relief in this case, that's something we're happy to do.
All right. I had questions about your argument that this has to be done, that this relief has to be sought through habeas corpus.
Yes, Your Honor.
There are a lot of cases from the Supreme Court and this court recognizing, I mean, again, Clark is the chief one right under the Alien Enemies Act, that when someone is bringing a procedural challenge, that two things, a procedural challenge, you don't have to go through the ordinary individualized decision making that you do for immigration challenges, removal challenges. That you can have class actions that bring challenges to the procedures by which removals are being implemented. And that's not a habeas claim because it's a challenge to procedures. And married to that is that not one of these plaintiffs, or as best we can tell, people in the class, is asking to be released from custody. And the Supreme Court has said time and again that when you aren't being asked to release from custody, in fact, they want to stay in the U.S. custody. No one's challenging the right of the government to detain them. But habeas is not the right vehicle. You've got Thurgossian, you've got Munaf versus Green. It's not the right vehicle. And in Clark, we allowed a lawsuit by an organization and 159 parties challenging application of the Alien Enemies Act.
Your Honor, I disagree with that for three reasons. First of all, the procedural right here that the district court derived in its order this morning essentially comes out of a string set of habeas cases. And so the right that the district court has defined here is clearly, to the extent that it exists, a habeas right.
No, it's a right to have procedures and opportunity in place, notice and opportunity in place across the board for everyone who's being removed, not detained, removed under the Alien Enemies Act.
Your Honor, I think two more responses to that. One is that the right at issue is being derived from habeas, and that's very important because it means that APA jurisdiction isn't available. Here's how this court addressed a very similar case in LeBeau versus Christopher. it said that the key to plaintiff's inability to pursue a suit here is jurisdictional and rests merely on the availability, not the actual seeking of habeas relief elsewhere. This court then further went on to explain that, quote, the availability of a habeas remedy in another district ousted us of jurisdiction over the alien's effort to pose a constitutional attack to his pending deportation, end quote. And so what I think you have here is the district court found a right derived from habeas cases. And the fact that it sounds in habeas means under LeBeau versus Christopher, it has to be.
I'm very confused. I'm very confused because we've got plenty of cases, and the Supreme Court's got plenty of cases that say when you're not asking for release from custody. Munaf was someone who said, I'm happy to be in the U.S. custody. Please don't release me to Iraqi custody. And that's right. And that sounds very similar to here. We are not probably not happy, but they're not disputing the right of the U.S. to detain them. What they are disputing and challenging is the capacity of the U.S. government to release them to Salvadorian jails without any advance notice and due process of whether they even qualify under the proclamation. That's not release. And we have said time and again, and the Supreme Court has told us, which is much more important, that's not habeas. Whether it's arising in an immigration context, a war powers context, like the war in Iraq, it's not habeas, and that is addressed through the APA.
Your Honor, I disagree with that. I agree that Munaf is an instructive case, but I think it cuts the other way. Here's how the Supreme Court characterized it, and I believe this is how you were characterized as well. It's like, here the last thing petitioners want is simple release. They essentially wanted to stay in custody, but nonetheless, I believe it was part 2 or part 3 of the Supreme Court decision in Munaf held that habeas was available, and then in part 4, it held that habeas petition failed on the merits. But the first issue presented was whether or not you could bring habeas in such a circumstance, and the answer to that was yes. And
the Supreme Court held it again in Versailles. Sorry if I'm saying it right. Versailles, right? Filed habeas petitions in an effort to block their transfer to Iraqi authorities, rejecting this use of habeas.
They rejected it on the merits, but they didn't say that habeas wasn't available. And I think Therasighium is a different case. That actually was a challenge to the procedures, but that doesn't sound in habeas. But here, it does sound in core habeas, and let me explain why.
No, it's not. It's a procedure. You don't have any procedure, at least as of Saturday when the TROs issued. At the time the TROs issued, and we'll talk about the second one, because I guess that sort of absorbed the first one. At the time it issued, there was no procedure in place, no advance notice sufficient to allow anyone to seek habeas. And there was nothing in the proclamation or in regulations or processes, don't have to be formal regulations, but processes adopted by those implementing the proclamation to give any such process. That's the argument. That's the issue. And that was not released. That is request for injunctive and declaratory relief due to failed procedures that Supreme Court said time and again do not cannot be brought in habeas because you don't want release.
Your Honor, I disagree with that on a number of fronts. First of all, again, on page 41 of the Saturday transcript, it's very clear that the basis of the TRO on appeal here was a frontal assault on the president's determinations that various statutory preconditions of the AEA have been satisfied.
Okay, but if we don't read it that way, if we read it as also being grounded in these claims for a process, and that's why they came in so fast. So we get away from those issues. They want declaration or injunction against TRO to start with, declaratory injunctive relief against removal.
Your Honor, the fact
and a failure to adhere to due process by those implementing the proclamation.
Your Honor, I disagree for 2 reasons. I think, first of all, their complaint still clearly includes those facial attacks on the sufficiency of the statutory preconditions. As long as those are in there, those are an attack on the government's ability to exercise a scintilla of custodial authority over the bodies of plaintiffs in order to either detain them or to remove them. And so as long as those are in the complaints, those sound in core habeas and cannot be brought here and would require transfer to another district or dismissal. But second, I think that the procedural one still challenges fundamentally in core habeas. It says you may not do anything to me under the AEA until you satisfy these preconditions. You are utterly without power to do so. I mean, that is the same sort of core habeas as asserting that a conviction is wrong because procedural requirements in a trial were not followed.
No, I don't think that's the same at all, because people don't go through a trial in this country without getting the gold standard of due process. And that was not happening here. I think that's a false equation. The problem here is, right, that they are challenging implementation of the proclamation in a way that never gave anyone a chance to say, I'm not covered. And if your argument is we didn't have to do that, it's an intrusion on the president's war powers, the courts are paralyzed to do anything, then that's a misreading of precedent. It's a misreading of the text of the Alien Enemies Act. And that can't be an unlawful intrusion on the president's powers. You just can't. The president has to comply with the Constitution and laws like everybody else.
On that, we certainly agree, Your Honor. I think that what has occurred here is that, aside from the shifting injunction issue, is that the district court has derived a right from habeas and then used that to create a non-habeas right.
Derived from habeas.
The pre-deprivation thing, the right that he found in his this morning's order, comes entirely out of habeas cases, and that's how it has to be served.
All right, so your theory is that they don't get to challenge it until they're in the Salvadorian jail? They don't get a pre-deprivation? I don't understand the pre-deprivation. They're already in detention. So if I'm understanding you right, are you saying that they don't have a right until they're removed from the United States in U.S. custody to challenge? This isn't a Niken situation. This is nothing like that. They're challenging an immediate removal, not under the Immigration and Nationality Act, but under the AEA without process. Is your theory is they're supposed to do it from the Salvadorian jail after the fact?
No, Your Honor, that it's that whatever right there are sound in habeas, much like Clabeau, where the challenge was to a non-Title VIII removal, that sounded in habeas and had to be brought as such. And the availability of habeas meant that the district court was outside of jurisdiction to hear other claims. That same logic means that the TROs issued below are invalid and should be reversed or
The
resolved.
Supreme Court in McNary versus Haitian Refugee Center, Reno versus Catholic Services said, we don't care about jurisdictional limits on claims that are supposed to go through ordinary statutory processes like Title VIII. When you are bringing a class-wide action for injunctive and declaratory relief about procedural failures, that would seem to fit this case.
Your Honor, we disagree. I mean, I think to the extent that it's procedural, it sounds in habeas, and hence this class does not operate properly.
Not procedural.
All right, everyone, as we continue